Okay, welcome everybody to this research seminar organised by the Department of English and Communication. Today we have Dr Jamie McKeown, who is an expert in law and legal discourse, legal linguistics, and Jamie is, I don't know why my computer's just frozen. Can you all hear me? Sorry, because my image is just frozen. Okay, sorry, I was panicking that my technology had abandoned me. So just to say that this talk is actually based on some research that hasn't been quite published yet. So it is important that although this this talk is going to be recorded, no private recordings are allowed. Okay, so in the interest of time, I would like to hand over to Jamie straight away so you can make your start.
Hello everyone. For those of you who have turned up in good faith, welcome to my talk, Clarifying Roe v. Wade, a contrastive analysis of the Metadiscourse markers in the jurisprudence of the Supreme Court. I'm, as Sal said, Jamie McKeown of the Department of English and Communication. If you're anything like me, I guess you're getting to the end of a very busy semester. So yes, thank you even more for coming and taking time to come here. Just to give you an idea as to where we're going to be heading today, we'll look at some background. So we'll look at some legal issues, some issues that are important within common law and central to the understanding of my inquiry. We'll also look very briefly at some case law, again, that's very central to the inquiry in this presentation. I'll take you very briefly through my data and conceptual approach. Then we'll look at some findings and hopefully by around 10-2 we'll be on to the summary and some reflections. Okay, this is a very text heavy presentation, so I indulge myself in some pictures at the start. Just to say that since returning to academia, I've followed a long-term interest in looking at legal discourse. Currently, within looking at legal discourse, I look at judicial discourse. And reflecting my educational background, I look at common law jurisdictions. So these are just three pictures of the Supreme Court or the Supreme Judicial bodies within the jurisdictions that I look at. So that would be the UK, Hong Kong, and today what we'll look at, a pressing issue in the US. Why look at judicial discourse? Okay, so I open with a quote from myself, so open quote. In living memory, marriage equality, sexual privacy, and reproductive rights are just some of the issues that have been decided in courts and communicated via the genre of written legal opinion. After other legal avenues have been exhausted, advocates from a diverse range of societies have sought court-based strategies, we'll unpack that, in their pursuit of various ends, a trend which has been gaining strength since the 1960s, close quote. So even in the past 20 years there, and sticking with the US context, although we could look at other jurisdictions as well, there have been huge decisions that have had big impacts for the lives and how people live their lives and how they order their lives. So, you know, today we're talking about abortion and what that right involves. Just 5 years ago, I mean, it's rather astonishing that we are in a situation whereby the right could be overruled. Just 5 years ago, Roe and Casey were affirmed by the court in a case called Hellerstedt. Obviously, you probably heard of Bush v. Gore at the turn of the century, which awarded the election to George W. Bush. We've seen big decisions on healthcare and the constitutionality of that. We've also seen big decisions in terms of sexual freedom in 2003, and also later in the past 20 years, we've seen decisions on marriage equality. All of these have come via judicial decision. Now, we'll unpack court-based strategies a little bit. Of course, what you can rely on your Supreme Court to do will vary according to the jurisdiction that you live in. So, for instance, in the UK, we can't really rely on courts to strike down acts of parliament because we have a doctrine of parliamentary supremacy. But in a place like the US, where they have a written constitution and the written constitution is above, it covers above everybody, all of the forms of law, the court can strike down laws. It can literally declare government policies and legislative acts invalid. So I want to read this quote to you, open quote. So this is in the 60s when sexual reformers were trying to reform sodomy laws. Not so successful, actually, considering the kind of civil rights jurisprudence that the court was engaged in. They were not particularly friendly in sexual liberty. But this explains what a court-based strategy is in the US. So open quote, if hopefully the Supreme Court upholds the lower court, then all of the sodomy statutes of the 48 states that still have them will have been swept away in one fell swoop. Years and maybe decades of laborious effort to get each of the 48 legislatures to repeal these laws will have been avoided. So think of the Supreme Court like a target. If you can hit it and you can succeed there, you supersede all other laws, you wipe them away. That's what happened in Roe v. Wade. So rather than going on a state-by-state basis, although political reform was happening, certain parties sued and were successful in the court. The court declared the right to bear or beget a pregnancy a constitutionally protected right. Okay. Another important concept for understanding common law and where we're at in terms of the current situation in Roe v. Wade is stare decisis. So stare decisis is a Latin term. It means stand by what has been decided. So in any given body of law within the common law, there will be a controlling precedent, and cases that have similar facts to that must be decided in a similar way. So in abortion, Roe is no longer the controlling precedent, it's actually Casey. People will look to Casey for deciding similar cases. Decisions of higher courts bind lower courts, so courts exist in a strategy, and decisions of past courts just bind future courts. Now, SCOTUS can, over the Supreme Court, I'll call it SCOTUS, is not bound to follow itself. It can overrule itself, but convention and the doctrine of fair expectations encourage respect for precedent. So there are certain rules that must be applied to justify an overruling of a past precedent. Okay, so I've talked about my general research being judicial discourse. Within judicial discourse, I'm very interested in bodily autonomy and privacy. Within privacy, I include both sexual privacy and medical privacy. Ordinarily, this can include a range of issues from things like euthanasia and assisted suicide to things like the ingestion of psychotropic substances. Do you have the right to commit suicide? Do you have the right to ingest psychotropic substances? Yes, no, who decides? These are issues that can play out in the courts, and I'm very interested in them as legal issues. It goes without saying that we live in very funny times. There is a flurry of scholarly activity around things in relation to bodily autonomy and medical privacy, around issues like vaccine and mask mandates, as well as informed consent. So, you know, there are definitely legitimate concerns there whereby after the Second World War in the Nuremberg trials, which were international trials, you know, we said that humans should be always have the right to keep themselves away from experimental medicines. What does that mean for some of the infrastructure that we have built, policies that we have made, and practices we have engaged in? These will be coming up in the future. Reproductive rights are obviously also fall within bodily autonomy. And again, this can range from things including, is contraception legal? Who has access to it? It can include things like the reproductive rights of LGBT couples, but it also, what we're going to talk about today, it can include the right to an abortion. Globally, the abortion right the pendulum is swinging two ways. So in a certain respect, it's swinging towards a much more conservative position. So states that had previous liberal arrangements, like Russia under the USSR and Poland under communism, had liberal arrangements, more countries are liberalising than are swinging towards conservatism. So we have seen liberalisation via legislation, the democratic process, in places like Argentina, Mexico and Peru. And we've also seen liberalisation via referendum, which overturned a constitutional amendment in Ireland. I think the Irish case is very interesting. Having grown up with a certain generation of Irish parents, I thought this would be unthinkable, but things can change. Liberalisation can come very quickly. Of course, perhaps, and maybe what we will see in the US, is that conservatism can also arrive very quickly in respect to this right. We should note that the US is slightly unusual in a global context, in that society-wide liberalisation arrived via judicial decision, not via legislation or referendum. And obviously, with what has happened in the US, it sits at a crossroads at the moment. Will it go more conservative or will it go more liberal? The court has famously, across 50 years of jurisprudence, has zigzagged. It's lurched liberal and then it has lurched conservative. Okay, so what were the, so now we'll look at a little bit of case law. What were the decisions that brought about liberalisation? It was Roe v. Wade and its companion case, Doe v. Bolton. Under these cases, SCOTUS mandated a general legalisation of abortion throughout the United States. Roe established a trimester framework that granted strict constitutional protection to abortion rights. This is very important. If you grant something strict constitutional protection, it means that the federal, state and local governments cannot infringe upon that right, and the court will subject any actions which are seen as perceived as infringing upon those rights to a strict scrutiny test. It's very hard to satisfy the strict scrutiny test. Under Roe's trimester framework, in the first and second trimesters of pregnancy, states could not interfere with the right to an elective abortion. In the third trimester, after fetal viability, states could intervene to protect the right of the life of the unborn. Doe v. Bolton, the companion case, did further specify a viability override, which said that if the patient's health is at risk, then viability could be overrode and there could be the right to abortion should be respected. So there are various theories. You know, the US, like European and Asian societies, started to liberalise abortion in the 70s, and in those societies, Ireland is a bit of an exception. It has remained relatively uncontroversial. Poland is also an exception, and states currently have much more regulatory power than they had under Roe and Doe. Why is that? Because of a case, this is the last case we'll look at, a case called Planned Parenthood versus Casey. This was a case in 1992, and whilst it did claim to affirm the central holding of Roe, that is, someone has a constitutional right to bear or beget a pregnancy pre-viability, it replaced first of all, it replaced Roe's trimester framework with a bimester framework. So pre-viability, post-viability, that has become problematic because viability is shifting all the time. So it's gone from 28 weeks to 21 weeks. It was 28 weeks under Roe, it's 21 weeks now. Casey also replaced the strict scrutiny test with a much lower and easier to satisfy test of undue burden. States could not place an undue burden in someone's path who was seeking an abortion. This gave greater regulatory power. It also arguably created the conditions for what are called trap laws, so targeted regulation of abortion providers. These laws are designed to make abortion much harder to access and more expensive. They've been relatively successful. There are seven states that have only one abortion clinic, which is astonishing when you think of the geographical side of your average US state. And we currently have a number of controversial cases heading to SCOTUS. Actually, we have one that we've currently been, I guess the opinions are in circulation. We've had oral arguments for it. That's a case from Mississippi, which bans abortion after 15 weeks. We also have a case heading from Texas, which bans abortions. It's the so-called fetal heartbeat laws, which ban abortion after 6 weeks. Very controversially, SCOTUS refused to enjoin that law. That means pause the law from coming into effect until there's been a trial. So meaning that for the best part of a year, there has been no abortion right in Texas after 6 weeks. This is a quote from Catherine Colbert. She was the lead, she's a reproductive rights advocate, and she was the lead attorney in Planned Parenthood v. Casey. She said, Roe v. Wade will be dead, open quote. Roe v. Wade will be dead within the year. The constitutional right to choose whether or not to have an abortion will no longer be protected, close quote. Why are we in this situation when just 5 years ago Roe and Casey were affirmed? Well, SCOTUS is most likely to overturn previous precedent when there has been a significant shift in the ideological balance. Successive appointments by the Trump administration has brought about such a situation. We have a solidly conservative SCOTUS with vocal pro-life justices sitting on the bench. So we may be on the eve of very dramatic changes in relation to this area of law. Okay. So I think that judicial discourse is incredibly important in how the potential impact it can have on people's lives. I think it's relatively explored and under investigated, especially for what I think we can do as language scholars, the kind of things that we could be adding to areas like legal pedagogy. That's not to do a disservice to the fantastic scholarship that has gone before me, and there have been some brilliant studies in areas like stance, as well as comparative studies between jurisdictions. Within common law, the phenomenon of separate opinions has been acutely overlooked. You can see lots of studies that don't take note of this. What do I mean by separate? So let's maybe take a step back and just think, what does a common law opinion do? It does two things. So it announces the outcome of the case, who wins, who loses, and it explains the rationale for the decision. So on what legal basis was someone awarded a victory, or did someone lose? Ordinarily, this should involve a majority of the judges. Sometimes the SCOTUS cannot reach a majority, so it issues a plurality position. A plurality position is basically the position that had the widest support within the court, but was short of a majority. Part of the weakness of Casey is that it's only a plurality position. It's actually not a unique feature, because more civil courts are allowing dissent. But okay, so a common feature of common law courts is that common law courts do not have to mask internal debate. So if you're a judge sitting on a case and you don't agree with the majority, you are free to publish a separate opinion. So separate opinions can be, thinking in mind of how we defined what an opinion does, they can be defined in relation to the majority opinion. We'll look at three main types of separate opinions today. I've just defined them for you. So we have regular concurring, a regular concurring opinion agrees with the outcome, again, who wins, who loses, and the reasons for deciding, but for some reason the judge feels motivated to write a regular concurring opinion. A special concurring opinion agrees with the outcome, again, who wins or loses, but not the rationale of the majority opinion. And then a dissenting opinion disagrees with both the outcome, who wins or loses, and the reasons for deciding the case. I know that's a little bit abstract. Let's just take a look at Roe v. Wade, the actual judgment. So a majority of 7 judges decided in the favour of the plaintiff Jane Roe in that case. Justice Blackman wrote the majority opinion, which 3 other justices, Brennan, Marshall and Powell, joined without further comment. So they silently joined the majority. 3 other justices, Douglas, Stewart and Berger, joined the majority opinion, but also chose to write regular concurring opinions. So that means they agreed with the outcome and the rationale, but they wanted to write an opinion. And 2 justices, White and Rehnquist, wrote dissenting opinions. I had a review and someone asked me, one of the reviewers, it's a very human question to ask, what does this discourse actually look like? So this just gives you an idea. This is from the Roe v. Wade judgment. You'll see it starts off with the syllabus. That has things like the facts, the procedural history, who wrote the opinion, how did the justices vote, who were the attorneys, who submitted expert briefs. And then by the time we get to the 3rd page, of course, the syllabus can vary according to how complex the case was. By the 3rd page in Roe v. Wade, we get to the opinion of the court, and it's here where we will find the binding law. So we've unpacked quite a lot. Today, I want to look at focusing on the 4 kinds of previously mentioned opinions. I want to look at how metadiscursive clarifying devices are used by judicial opinion writers in post Roe and Doe jurisprudence. I'll answer this in a primarily qualitative way, but I will just briefly present quantitative distribution of the markers across the opinions. Okay, so metadiscourse, very briefly talk about that. I subscribe to a reflexive school of metadiscourse. That is basically based on the insight that humans can perform a linguistic curve in their communication. It's concerned with the various discourse functions communicators enact when they explicitly refer to themselves as communicators and their communication as communication. Adol states, someone who I rely on her work a lot, open quote, if we take a broader perspective on metadiscourse as a linguistic phenomenon potentially realised in all sorts of discourse, we need to expand the scope to other genres, close quote. Obviously, that's what I'm doing in using metadiscourse within judicial discourse. There was a time when it was credible to say that metadiscourse was overly associated with academic writing. That's not true nowadays. There's lots of interesting work applying the construct to different forms of genre, different data. But beyond the novel nature of the discourse, why else could we potentially look at metadiscourse within judicial discourse? Okay, it's well attested in the literature that writers strive for clarity. It's important that judicial opinions are clear and that they can be understood, and that parties who are affected by them can understand them, or at least people who are representing them. Metadiscourse, as a subset of meta language, has an inherent clarifying function, and so I would argue is particularly suitable for the investigation of judicial opinion writing. How do writers explicitly structure their texts? How do they enter their texts to guide readers towards their preferred interpretations? These are legitimate questions to ask. However, today I don't look at a broad taxonomy of metadiscourse. I look at a specific subcategory, i.e. clarifying. Without preempting my results too much, I have noticed from previous research that clarifying devices yield insight as to aspects of legal issues that have been explicitly closed down, opened up, or remain contested. And that's very important for litigation. They expose potential routes for litigation. Okay, like I said, in previous research, I looked at clarifying. I noticed that they were a lot more frequent than I had seen in other people's research, and I think that can be explained by the genres. Again, it makes sense that judicial opinion writers would enter their text to explicitly clarify things, given that part of the role of a judicial opinion writer and a supreme body, judicial body, is to settle the law, keep it settled and not uncertain. I noted in that study that the markers were important sites of judicial signalling. Again, judicial signalling is when judicial opinion writers show or speak to lower courts where fissures exist, where they potentially could refer the case back to the Supreme Court, or where advocates could find a route for litigation. In that study, I used a binary distinction of markers without getting too technical. The reason being that I was using a bigger taxonomy, and a lot of the markers didn't fit a tripartite distinction that I will use in this study. I'll return to this point later. Just broadly understood, clarifying can be defined as explicit attempts by communicators to specify what is or is not being communicated, and they help communicators deal with the implications of their own discourse, as well as avoid potential misinterpretation. In doing so, it increases the precision of the discourse. Adol notes that the devices are particularly useful for strategically minded communicators. Again, SCOTUS opinion writers are very strategically minded. They will seek to close down positions that they don't agree with, or they'll seek to encourage positions that they would like to see further litigation on. A crucial point to note is that metadiscursive categories can look very different when examined in interactive data. So Morana notes, and I use her work in this study, I'll explain that in a moment, that when metadiscourse is applied to interactive data, the key parameters are immediately altered with inevitable consequences for analytical models. I take a much more expansive view of clarifying here. I also, just as an interesting side note, I attended a talk, I get so confused with the years these days. I think it was this time last year. It was by Professor Rorik of, I think he's from France. I know him from his fantastic work in evidentiality. And he was talking about the development of functional taxonomies. And he said, you know, we have to be really careful that we don't get into being overzealous in inventing new functional categories. And that before we invent a new category, perhaps we should inquire into the underlying nature of existing categories. Again, what I'm saying is, you know, some of these markers don't look like traditional clarifiers that we've identified in monologic data, but I still don't think it justifies the invention of a new functional category. I know that sounds very research conservative, but I think there's a point in there's much to be valued in that point of not being overzealous in the invention of new markers. Recognizing that legal discourse is complex in terms of intertextuality and discursivity, I felt that I needed something in the present study to account for the different levels of specificity that the discourse, the clarifiers target. So I draw upon discourse targets from Moranan. She makes a tripartite distinction. Again, I wanted to use this in previous studies, but I didn't find it had a great explanatory fit with many of the markers. But I did note in that previous study, not in the actual publication, but when I was doing the study, this could work for clarifiers. So she makes a tripartite distinction. There's three basic targets that a metadiscursive item can take: the communicator's discourse, the discourse of another, and the general communicative situation. What kind of, it's just worth sitting back and thinking, well, what kind of insight could this garner by using this this tripartite distinction? I've started to notice that looking at clarifiers that are interactive, so they're clarifying the meaning of the whole case, we can literally see what domain of law does the case fall within. So is this a case on, we'll see an example on abortion, or is it a case on conspiracy to deprive someone of their constitutionally protected rights? Sorry, I've left my email open, you can probably hear it ringing. In dialogic targets, we can see insight like how much has the majority, in referring to the points within the dissent, controlled the dissent. So when majorities don't control the dissent, it can increase their influence. And then in the monologic, that is when the monologic targets, when a discourse writer clarifies a point in their own discourse, we can see how much nuance has been expressed here, how much room is there for manoeuvre. Okay, so onto my data. How are we doing for time? Okay, quite good. My data, I took a sample of 40 opinions. These were taken from cases that were orally argued. That means they went through all of the cases and the litigation, they went through the normal litigation process, so through the levels of the court, and were delivered as signed opinions. So they were not opinions from the shadow docket. That's when the court has to deal with things very quickly and doesn't issue signed opinions. I took 10 majority opinions, 10 regular concurring, 10 special concurring, and 10 dissenting opinions. My analytical procedure was fairly straightforward. I used the corpus tool, although I wouldn't necessarily call this a corpus study, but I do find that tool very useful. Step one, I went through the data and I identified the metalingual and the meta-interactional keys. Having identified those keys, I then looked for those which could be seen as having a clarifying function. And at the same time, I assigned a discourse target to any of the clarifiers. Okay, how did I identify the meta-discourse? I know this glosses over a lot of nuance in Adol's work, but she basically gives a number of identification criteria that can be condensed into 3. So when looking at a candidate item, it must be reflexive of communication as communication, or a communicator as a communicator. The item should refer to something within the current communicative situation, so that would be within the current judgment. just the meta-discourse item, the co-text, we don't need to be concerned with that. And the discourse item must be explicit, so expressed in words instead of things like prosodic features or numbers. There are shifts within both the broad school and the narrow school, which actually looks at utterances and says if it has a reflexive function, then it can potentially be regarded as meta-discourse. That's not an approach I take, but it is, of course, one that's I respect. Give you an idea of how I identified some of the markers. So we could argue in these two examples, and I won't read them, that clarifying is taking place in both of them, but to fall within the remit of reflexive metadiscourse, again, we need something that is indexical of communication. So we do not suggest, the verb suggest clearly indexes the communicator as a communicator. But in the second one, the mental state predicate, we do not believe is a metacognitive, not metalingual. I fully recognise that within the broad school, you could account for this as perhaps a hedge or a booster. To give you some examples on the individual markers. So here, the metalingual key is provided by the noun question, and I'll just read the first part. We do not revisit our abortion precedents today, but rather consider a question of remedy. So it's clear from the co-text that the clarifier clarifies the overall direction of the whole discourse. It classifies the case. I don't want to get too much into this because of time, but this example is there's a lot of this type of clarifiers within the body of law. Now, you know, never rely on the media to, you know, report the content of a common law opinion, but you will often see in media discourse, they'll say things like, well, you know, Roe v. Wade has been affirmed lots and lots and lots of times. Actually, it's questionable. Here, the judicial discourse writer is clearly saying this case does not speak to our abortion precedents. It just speaks to a remedy. It was interesting when the Conservative majority refused to enjoin the Texas law, so refused to stop it from going into effect. They also took effort to say, oh, but we're not speaking to the constitutionality of Roe or Casey. Okay, the dialogic example. This is, I'll just read it. This is not to say, as Justice Thomas and Justice Kennedy claim, blah, 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 blah. Okay, and something to note that a negative statement is common in clarifiers. I had a rebuttable presumption that if a negated form occurred with a communicative verb, then it was an act of clarifying. That's not to say that there can't be positive acts of clarifying, because there can. The noun question often occurs in positive acts of clarifying, as do lemmas of the verb mean and the preposition about. Of course, you know, this is not to say, of course, it does flow from the writer persona, so in a certain respect is monologic, but it's very clear if we look at the co-text that the writer is responding to a specific point in the discourse of the dissenters. And then finally, we have a monologic act of clarifying. I read this whole sentence. To say that restrictions on a right are subject to strict scrutiny is not to say that the right is absolute. The first occurrence of the verb say, I would regard as an act of saying. It's just, it's communicating that something is being communicated. But the second negated form is an act of clarifying. Again, negated forms are frequent in acts of clarifying. Just again, to give you a bit more about my operationalization, a bit more insight around that, I used the sentence as an analytic convenience. So if there were, say, two metalingual keys that were both performing an act of clarifying, I would only count one instance of clarifying. So here it's clear that the writer is just clarifying his own point, and it is actually it. So some of the findings. So dissent writers use significantly more interactively targeted clarifying devices, again reminding you that dissents disagree with both the outcome as well as the rationale of a majority decision. I'll give you an example. So this comes from a case in which the majority struck down 6 provisions of a state law. It's by, this dissent is by Sandra Day O'Connor. And she says, the only question properly before the court is whether or not a preliminary injunction should have been issued to restrain enforcement of the challenged provisions pending trial on the merits. Interesting that she asserts the clarifier in terms of exclusivity, so the only question, as well as correctness, that's properly before the court. The clarifier amounts to an accusation of judicial overreach, and this dissent represents a kind of watershed moment in the court's abortion jurisprudence. So when Roe and Doe were in the ascendancy from the 70s up until this period, 86, the court was very zealous in striking down any attempts to regulate abortion. But after this dissent, which was very influential, it started to become much more judicious. So it wouldn't simply strike down laws, it would just pause them and then have a full trial and consider whether or not the provisions were, the types of reforms being proposed were constitutional. Again, we have an interesting example. In this case, the majority denied that blockades around abortion clinics constituted discrimination against women. Let me read the example. So she said, the judicial opinion writer says, this case is not about abortion. It is most assuredly not about the disfavouring of abortion by state legislatures. Rather, this case is about whether a conspiracy to deprive members of a protected class of legally protected interests give rise to a federal cause of action. This is very interesting. If we look at the date, again, going back to the start of the presentation, this is 1993, so it's after Casey, where the court has introduced the undue burden test, which it doesn't have the same teeth that the strict constitutional, strict scrutiny test had. So she's using clarifiers to distance the current case from the court's weakened abortion jurisprudence, and she's judicially signalling more favourable grounds, i.e. conspiracy, which is subject to strict scrutiny, on which a claim could be made. Interestingly, after this case, the court became less lenient with regards to activities like blockades and protests around abortion clinics. Okay, let's start look at the dialogic clarifying. So all three types of separate opinions use significantly more dialogically clarifying devices than majority opinions. We'll start by looking at the regular concurring opinions. So again, that agrees with both the outcome and the rationale of the majority decision. In my data, sorry, I need to drink some water. In my data, I found that regular concurrence writers used dialogically targeted clarifying devices to support the majority rationale. There are conflicting views in the literature as to the impact of regular concurrences. So Corley presents, actually, let's start with Ginsburg and Scalia, both justices of the court, writing extrajudicially, have claimed that the court speaks strongest when it speaks unanimously, and that any type of separate opinion weakens the authority of the court. But Corley presents convincing evidence which suggests that actually a majority decision with a strongly supporting regular concurrence is more influential in the lower courts than a majority decision that doesn't have a strong supporting regular concurrence. I'll give you an example. So this was an unusual case in that it was the court lurched towards a conservative direction during what would be the ascendancy period of Roe and Doe. In this decision, a Conservative majority upheld a denial of state funding for non-medically necessary abortions. Like the court, I do not read any decision of this court as requiring the state to finance a non-therapeutic abortion, the writer says. And it was this regular concurrence very much supported the majority opinion. Could it be argued that that helped subsequent case law, which went even further? I don't have them in my sample, but the court later said that even states were not even required as a result of the Hyde Amendment to even fund medically necessary abortions, which is pretty shocking. So coming on to looking at the use of dialogically targeted clarifying devices by special concurrence and dissent writers, they used these in a similar way to attack the majority rationale, and principally they were highlighting omissions within the majority opinion. Again, if we think, so in a monologic form, you know, in Metadiscourse, we're very comfortable with the use of clarifying devices to say what you are or you're not saying. But in a dialogic form, I would also argue that clarifying devices can be used to say what someone is or is not saying. So in this case, it was a case involving minors requiring abortions. The majority struck down certain requirements, but they did uphold a judicial bypass procedure. A judicial bypass procedure is a procedure whereby a minor who cannot get the consent of their parents can go to a judge before a court and show that they are mature enough to elect to have an abortion, and the court can step in for the parents. So in this case, the judicial opinion writer says, is the judge expected to know more about the woman? So there is some gender biased language in this. I apologise on behalf of the court. Is the judge expected to know more about the woman's medical needs or psychological makeup than her doctor? Should he consider the woman's financial and emotional status to determine the quality of the life of the woman and her future child would enjoy in this world? Neither the record nor the court answers such questions. So the clarifier here is highlighting an omission within the majority's opinion. Again, this is a potent criticism because SCOTUS is supposed to provide guidance to lower courts. So the opinion writer is saying, so telling lower courts send it back to us, or it's telling advocates litigate because we're obliged to answer this question. Another example, so in the majority of cases within the dissent data, the dialogically targeted devices targeted the majority opinion, but I had 3 examples where the dissent uses these devices to target other separate opinions in the same judgment. So I'll read this and I'll explain what's taking place. So the opinion writer says, third, the majority and Justice O'Connor argue that this court generally defers to lower federal courts' interpretations of state law. However, a decision drafted by Justice O'Connor, which she inexplicably fails to discuss, makes clear why deference is inappropriate here. So again, the clarifier is highlighting an omission, but this is, you know, it amounts to, there are 2 accusations here. So there's one, it's personal inconsistency leveled at Justice Sandra Day O'Connor, and perhaps more importantly, it's what this could amount to an accusation of what's called per incuriam. So that is when a decision is made in ignorance of a binding and relevant authority. So if she's ignored a relevant authority, that's grounds to overrule the current case in future cases. Okay, so onto my summary. How am I doing? Good. Dissent writers use significantly more interactively targeted clarifying devices. Given that dissents are driven by ideological differences, it makes sense that they would use clarifiers to challenge the fundamental grounds on which the case is decided. Regular concurrencies, special concurrencies, and dissents all use significantly more dialogically targeted clarifying devices. Again, the fact that the separate opinions are motivated out of not silently joining the majority makes sense. I would argue that they have more of an over-orientation towards the majority opinion. Special concurrencies and dissents use the devices in a similar way to pick apart the rationale of the majority opinion. Supporting previous work by Corley, I think, although I only look at one marker, I think, you know, looking at the data, regular concurrencies and special concurrencies should not be lumped together in analysis. They should be distinguished, and actually special concurrences are more similar to dissents. I would argue that clarifying devices appear to express the prescient tensions within the law. If you look at them, you can also, and I do have the hindsight of 50 years of jurisprudence, but looking at the clarifiers, you start to see those trends subsequently develop in subsequent cases, and an ability to identify and extract clarifiers could be very useful to those engaged in litigation. If you take the body of law and you look at what has been clarified at the various levels, you will see potential routes for clarification. Those are my references, and thank you